what are some defenses to causes of action for negligence? First off, there's a doctrine called contributory negligence. Now, contributory negligence is not present in most states. It has some relics or some application in very few states and in specific circumstances. But generally, this means that if a plaintiff sues a defendant for some form of harm suffered because of the defendant's negligence, if the plaintiff was in any way at all negligent in bringing about that harm, even a minute amount negligent in bringing about their own harm, then they cannot recover from the plaintiff. Now, this is a harsh result because or they cannot recover from the defendant. So say the defendant is 99% negligent for causing the harm to the plaintiff, and the plaintiff is 1% negligent. Contributory negligence would say that the plaintiff cannot recover. A related doctrine is called comparative negligence. That is where you compare the negligence of the plaintiff with that of the defendant. So if the plaintiff's negligence is greater than that of the defendant's, 51% to 49%, then the plaintiff cannot recover from the defendant, okay? But if the defendant was 51% negligent and the plaintiff was 49% negligent, in that case, you have a 2% difference, right? So if the court awards damages of $1,000, 2% of $1,000 is $20. And that is what the plaintiff could recover from the defendant. So there is a comparison and an offset there. So the defendant's negligence is offset by comparing the level of negligence of the defendant, okay? And then the last defense is assumption of the risk. That's when a plaintiff knowingly assumes the risk of a situation and thereby is blocked or stopped from recovering from the defendant because they knew and appreciated the risk of the situation and they voluntarily assumed it. So in that situation, you would be blocked from recovering due to your assumption of that risk. Now, one aspect of assumption of the risk is that people who lack mental capacity, such as children, cannot appreciate the risk of a situation. So even if you mark something as dangerous, a child cannot appreciate that risk. So if a child or incapacitated person were injured by that situation, assumption of the risk would not be a valid defense for that.